we're going to today be talking about chapters in a book that we co-edited. So it's a collection called eAccess to Justice. So along with Fabien Gélinas, who is the principal investigator of Towards Cyber Justice, we put together this collection that was published by OTTAWA Press, which is freely available to download online. It's an open access publication. So it brings together the work of scholars, judges, lawyers from a number of countries to focus on this question of the relationship between access to justice and in particular digital technologies or ICTs, and thinking about the ability of ICTs to actually foster the fundamental values that are often associated with or underlying justice. After this introduction that I'm going to give you, each of us are going to speak to a part of the book, the part that we were responsible for editing. So the first part, Justice, Values, and Digitization, is the one that I'll focus on. The second one, Courtroom Interactions and Self-Empowerment, is one that Jackie's going to speak to. And then thirdly, Fabien will speak to the question of toward new procedural models. So just before diving into the first part of the book, I thought I'd tell you a bit about the Cyber Justice Project. So it's a 7-year SSHRC-funded MCRI. It's actually turned into almost 9 years, I think, with extensions. It's actually, I think, bound to end this spring. It's inevitable. The project's, as I said, led by Fabien Gélinas at University of Montreal. It brings together 36 international researchers from 20 universities worldwide, working in multiple disciplines: law, information studies, anthropology, philosophy, engineering, business, and others, to study how we can improve justice, or whether we can improve justice using information communications technologies. And it incorporates thinking both about concrete responses as well as sort of critical sociological, socio-legal, socio-technical analysis. And so part of what's been unique is the connection between the project and the Cyber Justice Lab, where there are programmers and developers actually engaged in developing technology that responds to justice needs, justice system needs. So one of the projects is an online dispute resolution system for small claims court cases in Quebec. And there are a number of projects like that. So it's a project that combines the sort of the two spheres. One of the interesting things I think for me as a lawyer in the group really has been this challenge to think carefully about what we mean by access to justice. So one of my first, so my working group combined engineers, in particular engineers and lawyers, and one of the first things that we were sort of talking about, well, how can you program something that actually facilitates access to justice? And they said, well, first you'd have to tell us, well, what is access to justice? What do you mean by that? And then that called upon the lawyers in the group to start saying what they meant, and then quickly you actually realized that you don't all agree on what it is that you're talking about, or you don't know what you're talking about, or you never actually thought about what it was you were talking about. And so this interdisciplinarity of it was a really great challenge for us conceptually to get clear or clearer about what it was that we meant by that particular term. So the project itself was divided into working groups, as you've heard. The first one, Digitization of Justice, that I am leading. The second, Jackie's leading on limits of digitization, looking a lot around constraints and limits that prevent successful integration of technology into justice systems, in particular sort of including courtroom rituals, understandings of fundamental principles, and so on. And then working group 3, led by Fabien, on new procedural models, really thinking about current judicial and extrajudicial practices and whether they sort of continue to be relevant, whether they need to be modified, whether they need to be abandoned, and what a process would look like if you were to sort of reshape think about reshaping some of your sort of fundamental thinking around what it means in particular to have a justice system as in the sense of courts, or whether really the justice system in the sense of courts is just almost anachronistic in terms of assisting people supporting people to resolve the problems that they have. And so the trajectory of the research over the years, of course, has inevitably led us to thinking more about artificial intelligence and the relationship of artificial intelligence and legal decision making, and that funding, if the funding gods are willing, is the sort of next project that we're wanting to think about, and in particular, what relationship AI has with either empowering or disempowering users of justice systems. So you can find out more about the project and our results on the project website. So I'm going to say a few things about part 1 of the book, which was the outcome of our midterm conference. So this section of the book has 4 chapters. It's called Justice, Values, and Digitalization. And so my introduction to the 4 pieces in the book is called Fundamental Values in a Technologized Age of Efficiency. And I sort of raised that the term efficiency was a problem of mine throughout. I have many problems throughout the project, and it was very frustrating, especially to people who knew a lot about technology, because I'm very concerned about this word efficiency and the degree to which efficiency has come to run our conception of what access to justice is. So access to justice means less time, less resources devoted, and it's sort of in that sort of unquestioning. One of the authors calls it tailorized justice, the sort of the mechanical march to predictable, fast outcomes. And of course, we can't be unmindful of the fact that cost is a major inhibitor to access to justice, obviously. But this sort of whole numeric tone of many conversations around access to justice I find quite disturbing. So when I wrote the intro to this section, I started with a quote from my favorite theorist on the politics of technology, who is Langdon Winner. And he wrote in 1986 in a book called The Whale and the Reactor, in the 20th century, it is usually taken for granted that the only reliable resources for improving the human condition stem from new machines, techniques, and chemicals. But as we make things work, what kind of world are we making? And so this immense faith that Western societies in particular have placed in technology's capacity to improve the human condition, and the almost automatic mechanical equation of technological change with progress is also at least rhetorically evident in justice systems. And we see this regularly. I took a look at some of the sort of if you look at some headlines, justice systems that aren't seen as embracing technology are regularly labeled. They're backward, they're lagging behind, they're unadvanced, they're even embarrassing. And so the 4 chapters in this part of the book really start from a different position. They take a different path. They don't assume that technology can necessarily be equated with improved justice systems, nor do they assume that technology is unrelated to improving access to justice. But they push for thinking about values that go beyond efficiency, and to start looking back to some fundamental values like transparency, equality, privacy, that have been connected to the idea of a justice system's contribution to a well-functioning democracy. And so the section starts with a paper from Renaud Bouchard, who is a specialist in rule of law projects and works in African investment law. It's called Cyber Justice and International Development, Reducing the Gap Between Promises and Accomplishments. And so the chapter really frames the critical discussion of technology that sort of encompasses the chapters within part one by focusing on cyber justice initiatives in the international development context. So the analysis is specific to the international development agenda, but it highlights really a number of universal lessons with respect to implementation of technology in the justice sector. He shows how case management systems, what he called justice showrooms, so courtrooms that are showrooms in his view, can and have been used to create visibility and media attention, designed to supposedly to stimulate faith in court systems in so-called developing economies, rather than addressing the issues that were of most relevance and importance to people who live in those countries. So in addition, he says, to the fact that we've never demonstrated that these sort of mega models of sort of broad sort of technological overhaul all at once are actually effective in improving access to justice, even from an efficiency perspective. There really has been a prioritization of this notion of efficiency, and very little notice taken of fundamental issues like procedural compliance, making decisions in accordance with the rule of law, and the inviolability of basic rights. And so he argues that the technologist sort of technology worshiping vision that has really tended to predominate in the context of cyber justice initiatives in international development really leads to celebration of technology for technology's sake, and allows for this constant postponement of measures to determine whether or not what's happening is actually effective or even more centrally meaningful for the people who live in the countries affected. And so his idea that there's been a focus on efficiency alone, sort of how many cases can you sort of file in a system and how quickly can you do it, has really meant that these systems have avoided talking about basic rights that he says are key for creating conditions of trust that are actually required for human rights respecting economic development. So his call for more effective assessment tools is interestingly, and not as a direct result, but taken up in the second chapter by Gianpiero Lupo on evaluating e-justice, the design of assessment frameworks for e-justice systems. So what Lupo does in this chapter is look at other models of evaluation of justice systems that have really relied on strict business-based information systems, evaluation systems, and to add to those frameworks, to think about what it would mean to add to those frameworks other values that are considered fundamental to justice, including privacy, equal access, transparency, judicial independence, and so forth, and then to try to come up with an evaluation model or framework that can be used in justice to test or assess cyber justice projects around the world, and they've actually begun testing that model in Italy. The next two chapters, one by Graham Reynolds and one by Nicola Vermi, look more sort of specifically at cyber justice initiatives and fundamental values of free expression, often expressed in the open court principle, and privacy. So Graham Reynolds, who's a prof at UBC's chapter, The Role of Courts in Assisting Individuals in Realizing Their To-Be Rights to Information About Court Proceedings, analyzes the idea of access to court information from a Section 2B charter perspective, and tries to make an argument that what's happening is online media is increasingly replacing the external journalism, external media, in terms of being the intermediary between citizens and justice information and justice outcomes. And so he writes about how you could make an argument this is grounded in expressive rights under 2B. But all the while, obviously, being mindful that the 2B rights to access to information are not absolute and are obviously tempered by concerns around other fundamental justice values, in particular privacy. And it's actually interesting the way that this ended up. This wasn't really, we didn't make people plan this, but the things flowed quite nicely. Nicola's chapter, which is the fourth chapter in the section, Privacy versus Transparency, How Remote Access to Court Records Forces Us to Re-Examine Our Fundamental Values, goes in depth and specifically to look at how historically the open court principle has sort of reigned supreme in our conception of what it means to have access to justice, and what technologized digital access to court records means in terms of compromising privacy. So whereas, yes, court records were open and you could go to the court office and look at the file if there wasn't a confidentiality order, you didn't. Or most people didn't. And now with the removal of that level of practical obscurity, online access creates serious questions around privacy and whether there's a need for thinking about rebalancing and recalibrating the relationship between the sort of free expression as articulated in the open court principle and privacy for parties and litigants in particular whose sometimes highly confidential information is contained in these records. And he puts a special emphasis on the concerns around commercial data mining from court records. So I think really the chapter, the section itself really is does try to be consistent with Winter's advice to try to think about what kind of world we're making. All four authors accept that cyber justice initiatives and technology can, it's possible, facilitate improvements in the human condition, can facilitate improvements in access to justice, but they outline different areas that demonstrate why we have to be careful and critical in thinking about the impact of technological artifacts on fundamental justice values that are key to improving access to justice and the justice system more generally.
So indeed, we have been working together for quite some time, and as I'm listening to Jane give this, and I haven't heard her give this particular piece, I'm realizing that the conclusions that come out of, and the perspective that comes out of the end of the first chapter, or the first section of the book, are exactly echoed in the second section with a slightly different focus. So the section of the book that I edited was on courtroom interactions and self-empowerment. And what this section was doing was looking at specific implementations of technologies in courtrooms and asking what the consequences of those were and what the lessons learned from the implementation of those technologies. And framing it all was a notion of troubling the technological imperative, that imperative being a message to the court system that the court system needs to catch up to current technologies, and a system in which technologically advanced judges are portrayed as dragging the system into a digital age. So there's a sense that we must move forward with implementing technologies in the court system because they will necessarily have a positive impact on access to justice. That necessary relationship and a necessarily positive relationship is one that these chapters together, I think, question, and in the end I'll come around to that. The first of the chapters was written by Donald Horowitz. He looked at access to justice technology principles, access to and delivery of justice. And specifically, he was working in the Washington court system in the 1990s and headed up a working group that developed access to justice technology principles. So he and his working group were empowered by the court system itself to develop these technology principles to ensure as best possible that the court system was implementing technologies in a way that was going to improve access to justice. As any good individual developing these kinds of principles did, he obviously focused on consultation with a broad range of stakeholders within and without of the justice system. The resulting principles emphasize a number of things. They emphasize the importance of just results. They emphasize a balance of openness and privacy, hearkening back to Nicolas' paper at the end of the chapter, the section Jane talked about. They emphasized a neutral forum, and this is the idea that implementation of technology must be done in such a way that it doesn't disenfranchise any individuals, parties in the justice system. And emphasize public awareness and use, so that the public needed to be aware of the implementation of technologies and able to use those technologies. What was really wonderful about this particular initiative is that these principles were adopted by the court, so that they are principles that have existed since the late 1990s and have served to frame the adoption of technology within the Washington court system. And moving forward have helped to ensure, and obviously not necessarily ensured, but helped to ensure that technology as implemented within that system is going to further the goals of access to justice. And this initiative is certainly one that is important in that it provides that system-level guidance, which is often lacking, because if you look at the implementation of technology in the courts, often it happens on a courtroom-by-courtroom basis. So to provide this overview and to have a justice system, a court system that's forward-looking enough that they're willing to adopt it was quite a tremendous outcome. The second chapter by Sherry McLennan, entitled Empowerment, Technology, and Family Law, looks at the implementation of online self-help guides for family law in a context of, in a legal services context in BC, within a system that was designed largely to serve clients who were relatively low socioeconomic status and could not necessarily afford legal representation. So, and often we think of online self-help as a model response to the problem of self-represented litigants. And they developed this system and implemented this system and learned a number of things. Not surprisingly and importantly, they trained intermediaries to work between an automated system and the clients who are coming in and wanting to learn from, to benefit from that system. The system itself was designed not to serve not only those clients directly, but also to serve the information needs of those trained intermediaries, and also as a place that family law lawyers could go for information. So it was an information system designed to reach out to multiple populations, but when they looked at access of that specific population, the target population, you might think in the beginning, individuals who would come into the court otherwise or as self-represented litigants, they recognized the need for trained intermediaries. In their analysis of the implementation of the system, they recognized a few things, again, none of which will come as a surprise, that up-to-date content was critical. They emphasized accessibility, and accessibility has to do with the content itself, has to do with the way in which that content is presented, so it has to do with literacy level and the literacy level requirements of content. It also has to do with technology and the recognition that there are barriers to access of technological barriers of access to certain members of the population The use of intermediaries was in part a response to that. One of the things she recognizes on reflection is that, of course, those technological barriers and the technological divide is reducing as we move forward in time, but I still don't think we've reached a point in time where we can assume that technological access and technological capacity is universal. They also emphasize the importance of evaluation, of looking back, of recognizing that, of self-evaluating the implementation of the system, benefiting from the experience of other providers in this area, so looking internationally and nationally and internationally for models that would assist. In family law in particular, maybe to a greater extent. I think law is often an emotional issue, but in family law in particular, the issues might be especially emotional. So they talked about the need of ensuring that the content was delivered, especially if directly to clients, in such a way that it attended to the emotionality of the situation. They talked about the gamification of content as a way possibly to reach different populations. These are lessons that they learned in their implementation of this particular project. So it turned out to be a very good way to address a lack, address a lack in the justice system. It was in direct response to a lack of funding, and I think that everybody would recognize that universal representation would be a better outcome than assisting self-represented litigants to do a better job of what isn't their job in the first place. But she does conclude that done right, online self-help is empowering for many. And the other thing that is threaded throughout the chapter is a recognition that access to this kind of information, while perhaps most beneficial for self-represented litigants, is also beneficial for a lot of people who, not being within the legal system themselves, might want to understand the principles of family law and the ways in which family law decisions are carried out. Amy Salazin takes a different perspective. So Horowitz and McLennan are looking at implementations of certain kinds of technologies within the system, and they're doing this in a reflective way. Salazin is looking forward and saying, look, if we have a justice system throughout which we have implemented a variety of technologies, what responsibilities are incumbent upon actors in that system? And she particularly focuses on lawyers. So her question is, all right, what's the ethical duty of competence? Or in fact, is there an ethical duty of competence for lawyers to have competence with respect to the technologies that they encounter and potentially use in the justice system? She obviously draws the conclusion that there is, that this isn't something that is currently built within either legal education or regulation of the profession, but that it ought to be something that we take account of. She recognizes that there are two main reasons why lawyers need to have this technological competence. One is to identify potential malfeasance on the part of others, misuse of technologies in ways that are unfair. And the other is obviously to best represent the client. So we need to use those technologies in order to do our job as best we can, and in order to respond to situations when those technologies are misused. That raises, if we agree that there's an ethical duty of competence, then obviously it raises questions of oversight, and she recognizes 3 points of potential, where that could potentially be achieved. One is surveys and audits of competence, so reaching out to practicing lawyers and assessing what degree of competence do individuals have. The other is incorporating technical competence in codes of conduct. So developing principles that ensure that ensure that technical competence is on the professional radar. And the third is professional education initiatives. So while this is, in some ways, it may be somewhat of a time-limited issue, since lawyers coming up through the system now will have a greater familiarity with technologies than those who graduated 20 years ago, but nonetheless, technology is always changing, so the problem isn't going to go away. So while we will have a greater degree of education preparation in legal education for the use of technologies in the courtroom. It's very likely that we're going to continue to require professional education initiatives that assist lawyers in understanding new technologies as they come on board. Her conclusion is that courtroom technologies alter the system of justice, and actors in the system must understand the technologies and their impact. Interestingly, she focuses entirely on lawyers in this paper, and I think the chapter, and it makes a lot of sense. But obviously, exactly the same issues play out with respect to judges and probably various other actors within the court system. So this is going to be an imperative that we will need to address. Finally, David Tate and Meredith Rosner take a completely forward-looking view. So while the chapter that Amy wrote is kind of about, okay, how are we going to deal with this problem now? Tate and Rosner look forward to something which is on the horizon but is not yet widespread within the justice system, and that's use of tablets in the jury room, questioning whether they enhance performance while undermining fairness. So we're looking at various ways of presenting evidence in the system, and certainly we are looking at various ways of allowing jurors to interact with justice. They're particularly interested in the use of tablets in deliberation. So it changes the deliberation process entirely, of course, because what happens is each one of the jurors would have an independent access to the evidence as presented in the court, instead of being collectively reviewing and discussing jointly something that they're viewing together. They can all navigate in real time through the evidence as they choose to do so. So they set up a hypothetical situation of they ran a mock trial, and they had jurors who sat through the mock trial. They ran it with real lawyers, real judges. Everything was played out in the court, but obviously it wasn't. It was, I actually believe it was a real case reenacted. Jurors went away to deliberate, and they were offered tablets to do so. And they actually did a comparative analysis of jurors deliberating with tablets, and in another situation, the jurors deliberated using regular technology and display of evidence. They did find some important differences between the deliberations and decisions of the group that used tablets and the deliberation and decisions of the group that used the regular forms of evidence. Tablets seem to result in more vigorous debate, in a less of a willingness to shift opinions. So jurors in the tablet situation were less willing to shift their opinion in response to discussion in the room, and a greater proportion of guilty verdicts. Now, this is preliminary data, and they don't know whether this will be replicated, but you could make sense of it all. It seemed to fit with the idea that tablets encourage a greater engagement with the evidence. This, as a cognitive psychologist, this actually makes perfect sense to me. I would have anticipated that this would happen, because what you've done is you've put it literally in the hands of the jurors, the ability to choose their own path through that evidence, and not surprisingly, therefore, their ability to reason about that evidence in real time, in a room with their peers, but doing a very individual thing. So if you think about that, not at all surprising that those, at least the first two came out. The third effect might be attributed to the fact that at least in this case, and perhaps, and those of you more involved in the court system than I could speak more strongly to this, but Rosner and Tate suggest that it's the prosecutions more likely to be bringing evidence. Yeah, they suggest the prosecution more likely to be bringing evidence in a court case, and that as a result there will be a greater engagement with the arguments of the prosecution if there's a greater engagement with the evidence. And if you think about it that way, a greater engagement with arguments of one side of the dispute or of the courtroom interaction will probably lead you to more strongly support that side. I'd be very interested to see if this last result was replicated, but you can't make some sense of it. Ultimately, they conclude that there can be unexpected and potentially detrimental effects of technologies on the justice system. And in fact, I think this should be a refrain that we carry. We can't assume that the relationship of access to justice and technology is either necessary, that is, there could be no impact, or necessarily positive. And I think it's the latter that we really have to think about. So even if there is an impact, it may not necessarily be a positive impact, and actually, beyond that, it may be a differential impact. So the impact of technology in the courtroom can differentially affect access to justice among different players, different subsets of the population. So we need to proceed carefully to ensure that technologies achieve the positive outcomes that we envision.
So, as Jane and Jackie indicated, I was responsible for editing the third part of the book, which followed the lines of the working groups that the three of us headed, and mine was toward new procedural models. And there's a question mark at the end of that title in the book. The introductory chapter that I wrote is called Continuity and Technological Change in Justice Delivery in that book. So most of us who've studied law or otherwise encountered the justice system have been concerned in one way or another with access to justice. Those of us who've been around for a while, and I mean those of us who were, for example, around in the 60s, that's a long time ago for many people I talk to now, especially those I teach. We've all witnessed fairly bold initiatives that were intended to improve access to justice. We've seen legal aid programs implemented across Canada, and I'm sure that these have had an impact, and they're still having an impact. But billions of dollars later, they do seem like a bit of a drop of water in the ocean. They don't seem to make such a significant difference as we would have hoped when they were launched. We've also seen small claim courts implemented in various jurisdictions, and these held the promise of reestablishing a connection between, the stakes and the means that were used to resolve disputes, a connection between offer and demand to a certain extent. Those have worked to a certain extent, but they've also been plagued with delays, and they don't seem to have made such a difference as we would have hoped at the time. The access to justice problem is something we've been talking about for something like 60 years now, and we're still talking about it. So when ICT, information and communications technology, came about, the tech-prone people who were interested in justice immediately made the connection between technology and justice and what justice could do, what technology could do for justice. So that was the case in the 1980s when some research was done in artificial intelligence. We were talking about this yesterday with Jackie. What was done at the time was to try and establish expert systems using software where the software would replicate deductive reasoning that one found in very narrow instances of, for example, administrative law, things like unemployment insurance benefits and things like that. So there was quite a bit of hope that things would improve with technology at the time. This was also the case with the advent of online dispute resolution in the late 1990s and the early 2000s. There were new systems where online mechanisms, software platforms were used to resolve disputes at a distance over the internet. Examples of that would include the software that was used by eBay at the time, which resolved millions of disputes. I was involved in one project with ICANN, where we provided dispute resolution services online for domain name disputes back in the early 2000s. And then it's again the case with artificial intelligence and law. AI has become immeasurably more powerful. The potential is much greater because of, on the one hand, deep learning, and on the other hand, big data. The two obviously go together. So again, technology leads us to hope that it holds the key to better access to justice, to actually resolve the problems that we've been talking about for 60 years. And this was a central theme of the MCRI that brought Jane, Jackie, and I together. Now, with hindsight, I think we all agree that the practices and the norms and the assumptions of justice are more resistant to change than we had anticipated. I mean, whenever there's something new, there's hope, and anticipations run high, and enthusiasm runs high. But I think the legal system has proved much more resistant to change than we thought. So obviously, change is difficult because law's function is in part to resist it, and because the values that underpin the justice system are usually in tension, and they're also interwoven with norms and practices whose slow evolution is hard for us to grasp. So those are the themes that are addressed in the third part of the book. They're addressed from the points of view of sociology, political theory, and legal theory. Sociology by Pierre Noro, political theory by Daniel Weinstock, and legal theory by Clément Camion, who's a lawyer who works with Éducalois. So Éducalois in Quebec is the platform that provides legal information and is associated with the bar. There are also two case studies, as it were, about the implementation of technology toward access to justice, and both are in large federal-style entities. One is in Brazil by Katia Balbino, and the other one in Europe, that's Alexandra Kramer. So I'm not going to run you through each of the papers, but simply pick out the main themes that are addressed in the third part of the book. So on the general theme of resistance to change, I'll say a little bit more than what I've said. Obviously, law's resistance to change has something to do with the legal profession's ingrained conservatism. This is something we've all encountered, I think. But several of the chapters in the section link this conservatism to a purpose, that is the function or the purpose of law as a stabilizer of social relations. Now, law stabilizes social relations by pursuing predictability in decision-making, predictability in dispute resolution particularly. Now, one of the ways in which predictability is ensured is by pursuing normative coherence. So the legal system has to be coherent if it is to be predictable. And so this means that if you're changing one thing in the legal system, you have to consider the whole of the legal system. Obviously, that makes change much more difficult in law than it does in other areas. Another way in which law nurtures predictability is obviously by relying on procedure, by heavily relying on procedure or secondary rules, to use Hart's terminology. Now, if substantive agreement is not possible on a particular point, then we can agree on a procedure to resolve the dispute and to establish authoritatively what the rule is going to be for others. And so this generates normative clarifications not only for litigants but also for the rest of society. The resort to procedure also induces notions of due process that have almost become sacred in our legal system. This is particularly the case in common law, in the common law tradition, where this notion of due process there's a heightened sensitivity to violations of the principle of due process. It's obviously constitutionally recognized in many settings and many jurisdictions. So all of those are fairly obvious reasons why the legal profession will naturally resist and balks at the prospect of change in general, and in particular why the renewal of procedural models is difficult, because they're tied to this sacred principle of due process. On the theme of justice values more generally, we have one particularly important insight from sociology, and that's detailed by Pierre Noro in his paper, is that there are basically three levels of social action. This is something that's fairly well-trodden territory in sociology. So three levels of social action. One is the symbolic level, where you find the values in society. The second level is the normative level, where you find the legal rules. And the third level is the instrumental level, where people actually engage in social practices, and that's practices, essentially, what people do. And so these three levels basically combine to create very tight barriers to change. The reminder, I think, is very helpful in many ways, and particularly in identifying and analyzing a very common mistake that is made in all attempts at introducing change through law. That's to focus exclusively on the normative level of action without paying sufficient attention to the upper level, the values, and the lower level, the practices. Most of us who've studied legal reforms and legal transplants in comparative law would be familiar with this issue. You take a model law at the normative level, you transplant it, and it doesn't work because the values are not the same and the practices are not the same. That's a very obvious example of this phenomenon. And so deliberate attempts, similarly, to introduce technology in the legal process without considering the values and the practices are all bound to fail. And there are examples of those failures, not only in legal reform generally, but in the introduction of technology in courts. There's a further level of difficulty which is highlighted by Daniel Weinstock from the point of view of political theory. And he focuses on the difficulty that comes from the fact that at the symbolic or value level, the values are not coherent or necessarily coherent. They're very often in tension. We're pursuing different values. Those values can be recognized, but they are very often in tension. What the law does at the normative level is that it tries to make things coherent by feeding on those values, but they give an interpretation of those values which make things look coherent. But at the symbolic level, there are tensions between values. And so Weinstock concludes that any human institution must try to balance a large number of values that are sometimes related in very complicated ways. And there's no algorithm, obviously, to identify the right way to perform the balancing. Although there are many people who work on deep learning who will tell you now that balancing is indeed something that algorithms are able to do, which distinguishes them from what used to be done in the 80s with artificial intelligence trying to reproduce deductive reasoning. The algorithms today are able to infer things from the bottom, going up, as opposed to starting from the top and deducting to a result. The third theme I want to highlight here is the relationship between what I would call private harmony and the rule of law. I'll make what I mean a bit clearer in a second. So looking at access to justice, we've been looking quite a bit at online dispute resolution. And obviously, online dispute resolution is something that is inspired by ADR, alternative dispute resolution. And alternative dispute resolution is largely, or implies in many contexts, privatization, the privatization of justice, or using private means to deliver justice goods, essentially. And so there's a reflection around the impact of privatizing justice, and not just privatizing, but also moving from the litigation model to a conciliation model of dispute resolution. So it's hard to make this short, but perhaps the best way of making this short is to mention the new Code of Civil Procedure in Quebec, which introduced this revolution by mentioning in its first section, Article 1 of the Code, is essentially about private justice. I have 0 time left. Okay.
You can have a minute.
All right. So the theme that we're thinking about here is that the move from public to private on the one hand, and from litigation to conciliation on the other, has impacts on the rule of law in terms of making it very difficult for courts to act as stabilizers of social relations, essentially, notably through precedent and through the enforcement of legitimate expectations that come from law and contracts. So I'll stop here. The third theme, broad theme that I wanted to address is just a way of moving the conversation toward our next project, as it were. And that's the use of technology to increase access through awareness. And here I'm talking about the tools that are provided to anyone to improve access to justice, their understanding of law, and their understanding of the remedies that are available to them. I think this may be a key point for access to justice in the future with artificial intelligence. And that's because it holds the promise of reducing the gap in understanding that has always been there between the published laws and how people understand them on the ground.